Good evening, everyone. My name is Allison Rapond. I am one of the co-vice chairs for the Dallas Bar Association's Mock Trial Committee. We have the pleasure every year of putting on our state mock trial championships and then a couple of our regional competitions as well. We wanted to put together a panel of some of our very experienced presiding judges to give y'all a bit of insight into kind of some good things we see, some things we see that might be a little bit of a pet peeve, and give you a little bit of insight into what some of your often seen presiding judges see on an annual basis. We know that our students often ask us for feedback in rounds. We don't do that for timing purposes, so this is really a good chance for y'all to get some feedback on kind of what distinguishes good mock trial from great mock trial. So with that, I want to ask our panelists to introduce themselves, give us a couple of sentences about your name, your area of practice, and what your experience has been with high school mock trial. And I'm going to start first with Jamie Olin.
Great, thanks, Allison, and welcome everybody. My name's Jamie Olin. I am a partner at a small firm in Dallas that practices patent litigation specifically. And I've been judging high school mock trial in Dallas for about the last 10 years. So as a scoring judge for about half of that, and then I've been presiding for about the last 5 years. So it's great, and best of luck to everybody going into this season.
I'm just going to continue to go down my screen in the order I see it, and so I'll go next to Catherine Caston.
Thanks, Allison. Hello, everyone. Welcome. My name is Catherine Caston. I have been practicing law as a litigator for 34 years. 14 years of which were with the Attorney General's office, 10 years in a private firm against the Attorney General's office. Then I worked for the city of Dallas, and I've owned my own firm since 2016. And I've been judging mock trials since, good golly, I think 1991. And I love doing it. I enjoy the interaction. I enjoy watching everybody learn and evolve, and I appreciate being here.
Thanks so much. I see that one of our panelists, Robert Toby, does have, can only be with us for a couple of minutes. So I'm going to go and turn to him, let him introduce himself and give a couple of comments, and then we'll go back to the rest of our panelists.
Well, thank you, Allison. That'll save me from having to type, which is, always an issue. So I'm Robert Toby. I'm with Johnston Toby Baruch. I've served as a presiding judge a number of times. I've been a juror in mock trial, really enjoy it. I think it's a wonderful program that has benefited so many students and also the coaches, I'm sure, benefit from it as well. And we as judges and jurors benefit from it. So unfortunately, I've got a conflict, but I wanted to give a couple of comments. I thought this is a great opportunity to sort of let people know what we're thinking. First of all, objections. I do think they are overused. And I'm one, when I'm on the bench presiding, that tends to let everybody tell their story and let the evidence in, unless there's just something obviously wrong with the question, and then I'll sustain an objection. But it seems like a lot of the students are coached to do a lot of objecting, and I think that maybe they should be coached to know their judge. And once they have a couple of objections that are overruled, the prudent thing, I think, at that point is not to object too much, because you can kind of see your decision maker is not going that way. So that would be a suggestion, I think, in terms of objections. I do appreciate the back and forth. A lot of times, I think a lot of the objections, though, are pretty ticky-tack and would not be ones that you would see in court for that reason. So I think they ought to be schooled in that regard. The second thing that has bugged me for years is coaching the witnesses to look at the jury constantly. I've noticed it when I'm serving as a juror, it sort of backs up the thinking that you really are kind of doing a docudrama, so to speak, between the lawyer and the witness. And the juror is observing. The jurors are looking. The jurors are kind of watching the way they watch television. And when you're looking at the jurors, you're kind of invading the juror's space. And I do think there's an opportunity for that at a key point for the witness to look at the jury. But I certainly wouldn't look at the jury when, my name is Jane Smith. You don't look at the jury for that. And I think that's, at least that's my personal opinion. I know there's opinions to the contrary on that, but I just think it invades the juror's observation of the trial, and you shouldn't do it as much as it's done. And you don't really see it as much in court, I think, as you do in these mock trials. And so I just think that they ought to be coached to pick their spots. A really key point, look at the juror and deliver it. Other points, just look at the questioner and move on. That's something that's always bothered me as both a judge and particularly as a juror. So I just wanted to make those couple of points, Allison. And I think this is a great exercise. I wish I could stick around. Hopefully Melissa will be able to send out a summary of what people have said and think, because I'd be curious to hear what others think as well.
Now, do you think the video is going to be made available to our teams? I imagine it's going to be loaded up on some platform, so I'm sure it's going to be available for you to view later. I want to thank you so much for hopping on to offer this couple of bits of insight, and we appreciate you being here today.
Thanks so much. Appreciate it, Allison.
Thanks. You. So now I'll go ahead and go back to my introductions and let the rest of you finish introducing yourselves. Let's go down to Sanford Holmes.
Good afternoon or evening, you guys. So yes, my name is Sanford Holmes. I guess I am a 13-year veteran of litigation, prosecution, both meaning criminal and civil. But right now I practice in a small firm named Crane Stores doing construction defect litigation. I've been involved now with mock trial for around 7 or 8 years, and kind of started as a jury judge and been a presiding judge a few times now. And it's just always fun. It's amazing seeing what so many of you guys do. So I'm excited to do it again this year.
Thanks so much. All right, Stacey McNulty.
Hi, my name's Stacey McNulty. I practice patent litigation like Jamie. Did, trials at a firm for a while, and then went in-house where I was in charge of our global litigation. So the cool part there was I got to work with international trial teams, which I really liked. Putting on a trial in China is really different than putting on a trial in the US. And it's just really cool to kind of see those skill sets in action. I've been involved in mock trial for 7, 8 years. And I just love it. I'll be here for a long time.
Perfect. And I'm going to go ahead and turn now to someone who you're all familiar with, I'm sure, which is going to be Steve Gwynn, who's been a long time chair and now co-chair of the Mock Trial Committee, and does so much to make these competitions happen every year. So I'll pass it to Steve to introduce himself.
Thank you, Allison. Yeah, I've been involved with high school mock trial since last century. Started working on the program in 1999 and have been the chair or co-chair for the last 18 years. Have seen lots and lots and lots of trials. We've got a collection of very experienced judges, and I believe that you have the opportunity to learn a lot of different things today. And you're going to hear some things that are a little bit unusual that maybe you didn't expect. But what Mr. Toby said is, figure out who your judge is and what way he goes, and don't try every case the same to every judge, because all of these people do things very, very differently. But you can pick up, they will tell you very early on how they're going to handle things. Thank you, Allison.
Absolutely. Now I'm going to go to Shelley Joyner.
Okay, sorry. So first of all, sorry for not being as professional as I could. I'm trying to squeeze this in. I have to go teach here in about 20 minutes. So my name's Shelley Joyner. I practice probate and estate planning law. This is actually my second career. Before that, I worked 17 years as an operations manager for a giant shipping company. And this is going to be my 7th high school mock trial. And I genuinely enjoy it. The problems are always really, really cool. And I am continually impressed by how awesome the students are. I learn a lot from them every single year.
Thanks so much, Shelley. All right, Fred Moss, one of our regular problem writers and one of our regular judges.
Yes, I was a professor at SMU Law School for longer than I can remember, and when I was there, I taught the law school's mock trial teams for many years, and also involved in training of lawyers for many years with the National Institute for Trial Advocacy, and I've been judging mock trial now for probably close to 20 years, and over the last 10 or 15, I've generally been the presiding judge, which I love to do because I love to address the students directly and be up there and watch them from that cat's bird seat, so to speak, and because they're always very impressive.
Thanks so much. And last but certainly not least, Jim Young.
Well, good evening, everybody. My name's Jim Young. I am an arbitrator, mediator, part-time professor, and corporate and commercial lawyer practicing in Dallas with a large firm. I've been in practice for nearly 40 years. For close to 15 years, I've been involved as a mock trial judge for the high school mock trial program. And I have also coached mock trial at the collegiate level for the University of Texas at Dallas. I really enjoy mock trial, and I'm happy to share whatever thoughts I have with you all this evening.
Thanks so much. And I just want to thank, before I forget, thank all of you for being here today, for bringing your experience and your advice to help our wonderful high school mock trial students. And with that, I'm going to start with a kind of a more general question. What is one piece of advice that you would give to a student who is new to high school mock trial? And let's start with Steve.
Somebody who's new to high school mock trial.
Brand new.
If you're going to be a witness, this is what I tell absolutely everybody, you should read your statement the first thing when you wake up. You should read it at least once in the middle of the day, and you should read your statement the last thing you do before you go to bed. That statement should be sitting beside your bed, and that should be the first thing every single day once you get the problem, if you're going to be a witness. If you're an attorney, you must know the rules of evidence forwards and backwards, because that's how you're going to be able to try the case, and the rules of the competition. The rest of the things you will learn, but if you have those committed to memory, you set yourself up for success.
Great, thank you so much. Fred, I'll come up to you.
I agree with Steve. With regards to the witnesses and to the people who are going to examine them, it's critical, first of all, that the entire team be working together. Everybody knows what the objectives are, what you got to prove, or what you're trying to undermine. And the only way you can do that is if you have a firm grasp of the evidence, of the facts, and a very firm grasp of the law. And the critical part is the instructions to the jury, because that gives you your directions as to what you must prove or what you must try to show has not been proven. So the final jury instructions, you have to have those ingrained in your head as to, because that's your directions. The law gives you pigeonholes that have to be filled with facts. And you have to know what those pigeonholes are, because you have to know where to put the facts, and where the pigeonholes haven't been filled and the other side hasn't met their burden of proof. So you've got to know the law, you've got to know the facts, and you all got to be together, working together going in the same direction. And every examination has to be, what is the target? The target is the closing argument. The very first thing you do after you read all of the facts and the law is you do the final argument. And then everybody else, whatever they're doing, has to be aimed at putting some of the mosaic together. That is the final argument. Every question, every witness, all of your arguments, both opening and closing, are aimed at filling out the picture that you're going to draw in the final argument. So that's your map. Go there. You've got to have it down and all be working in the same direction. Okay.
Thanks so much. Jamie, what's one piece of advice you would give a new high school mock trial student?
So my one piece of advice is there is no one single right way to do high school mock trial. There is a lot of ways that you can approach doing mock trial and be equally successful. So for cross, for an example, I think a lot of people here, you have to be extremely aggressive as an attorney when you're crossing a witness. That can work. And I've certainly given tens to attorneys who have a very aggressive style, but I've also given tens to attorneys who have a much gentler, calm style and are able to get the same types of admissions based on their own personality and the way that they examine their witnesses. Same goes for witnesses. I have scored witnesses very high who use accents and really embody their character. I've also scored witnesses very high who don't do any of that, but just know the facts backwards and forwards and are great at fielding cross questions. So it's a great thing to discuss with your team, which is how do we want to approach this problem this season? And what elements of your own personalities you can bring into mock trial to be successful without necessarily picking up somebody else's personality because that's how you think it should be.
Thanks so much. And Shelley, I'm going to same question because I think this one is an important one and I want to hear from everybody on it.
So I'm going to very respectfully disagree with Mr. Toby. I like to hear good objections because a lot of times when folks are evenly matched up, you know, great, you've memorized your script, but objections mean you have to actually think on your feet and quickly. So a lot of times when there's two very well matched teams who both have really good cases, a lot of times the tiebreaker might be how you respond to, how you make objections and how you respond to objections. And then another thing too, that's kind of been a tiebreaker for me as well is witnesses stay in character when you are sitting there, but also don't be distracting. So stay in character enough. You know, Steve always talks about, you know, you can't have somebody that's, you know, playing the expert witness and then they go sit down and they're fiddling with their tie or their fidget spinner or whatever else it is. So stay in character, but not distracting when you go back and sit down after you've given your witness testimony.
Thank you so much. All right, Jim, same question.
Okay, for a new mock trial student, I'm going to climb up to about 30,000 feet with a little perspective. This process is mysterious, it's opaque, and it's intimidating. But y'all have to know that every one of you are capable of doing this. Every one of us once was where you are, and we wondered if we could, and then we did. You will, and what you will learn as you get into it is that it's really not mysterious. It's really not opaque. There's a reason for everything. Everyone has a role. All of the roles are vital. And you'll find that you're a member of a team and that you're contributing right alongside with everyone else. So don't let the formality, the mystery, and the opaqueness intimidate you or limit your willingness to participate. Dive in, buckle your seatbelt, get it on.
Thanks so much, Jim. Sanford, same question.
So I think I'm going to go right after Jim's point there. The best advice I probably received when I first started doing trial advocacy was that this is your courtroom. Claim it. It's all about the confidence that you bring to it because people, you do need to know the facts. You definitely need to know the rules. But truthfully, what people will respond to and what they'll kind of hear in your voice is your confidence. As long as this is your courtroom, you'll be able to address objections. You'll be able to clearly state what you want them to know, and their eyes will not leave you.
Thanks so much. Then finally, Catherine, I'll ask you that question as well.
Let me find my unmute button. Building off of what Sanford just said, yes, confidence has a lot to do with it. You may, make the wrong legal objection, but if you're confident in your argument, you still might win it. But also, this is a high school mock trial. Relax, enjoy the learning experience. It's a lot. It can be a lot of fun, and it's not the end of the world if something goes wrong. There's time always to improve and just relax and learn.
I'm going to apologize for my cat popping up in the background. He has a mind of his own. And Stacy, I realized I didn't ask you that question, so I want to get your insight before we move on.
I actually would piggyback off what Jamie said. I completely agree that find your style of advocacy. There's things that you need to memorize. Yes, there's things that you need to be able to ask questions that are yes or no questions. But at the same time, advocacy does not look one way. And I think my favorite part about mock trial actually is seeing people that are just totally different be successful in different ways and different approaches. It's my favorite part of mock trial.
Thank you so much. That's a lot of great insight. And now I'm going to go to our next question, which I think bounces well off the last question. It's how do you distinguish a great team from a good team? Kind of the teams that are getting your 8s, your 9s, sometimes even your 10s versus teams that might be average. So I'm going to, I know a couple folks have to hop off here in a little bit. So I'm going to go ahead and pass this to Shelley first. Sorry, Shelley.
This sounds like a slow pitch, but honestly, it's confidence. When you get up there and, you're looking at your notes and you go, and then you just start out kind of timid. Walk in there like you own the place. I'm going to believe you. It really can be the difference between if you start off and you're selling it to me like this is your courtroom, you've already won, the rest of this is just a formality. Keep that energy up, because if you're stopping and looking at your notes, and if your voice and your body language is constantly apologizing for something, then I'm going to have a hard time believing that you're in charge of the situation. So fake it till you make it.
Thanks so much. And Steve, I'll ask you, how do you distinguish great from good?
Thanks, Allison. Yeah, I'm one of those that has to run. Great from good. For me, it's fluidity between team members and structure of examinations. The examinations need to be logical. They need to follow a path that is achieving a point that is identifiable, particularly in direct and in cross-examination. And if you're an attorney on a team and one of your teammates is standing up asking questions, you know what they're going to be doing next. And if they're about to cross-examine or direct examine a witness on a piece of evidence, have that piece of evidence in your hand, so when they turn around, you're handing it to them. They don't walk over and open a booklet and flip through and grab something. A, you're saving time, which is at a premium in mock trial, and B, everybody's watching that you're engaged and you're handing your co-counsel the very next thing that they're going to ask a question on. And that to me is really how I distinguish good from great.
Thanks so much. Stacey, same question. What's great advocacy versus good advocacy for you?
I agree with what Steve said about the structure of the examinations. I think that's really important when there's an identifiable point, a logic way that they got there, and not a lot of fluff in between. I also, we've talked a little bit about objections, and I think that people have different feelings about them, but I do think that the way a team handles an objection, that is what goes from a good team to a great team. Someone who can confidently respond based on the laws of evidence, I mean, that would be a great team.
Perfect. Jim, what distinguishes great from good?
Well, for me, I look for really two things on that point. One of them is good, cohesive, supportive teamwork. Everybody has a role. Everyone fills their role. Everyone supports everyone else in their roles. Steve points out, don't make your counsel on direct fish for evidence. Hand it to him. Be ready. The other thing I look for is I want to see a team that doesn't lose sight of job one, which is tell your client's story in the way that reflects best on your client. Some teams tend to get down in the weeds. They get distracted. I got to win this battle. I got to win that battle. I got to do something else. get up out of the weeds, look at the forest instead of the trees. You have to tell your client's story to the best interests of your client at all times. And I see great teams do that consistently.
Thanks so much, Jim. Catherine, what do you consider great advocacy versus good advocacy, or a great team versus a good team? Oh, and I can't hear you. I think you're muted.
I'm going to have to stop that. Confidence, number one, if you act like you know what you're doing, then like was said, fake it till you make it. And a team that remains professional, going back and forth on objections, instead of, sometimes you can just feel the anxiousness building, and the teams that remain professional and know we're just arguing about, these legal issues, these words, that makes a great team for me. The other one that makes a great team for me is knowing that there are rules, and so objections are made based on rules, hopefully, so know what the rule is, so you can respond accurately. And the teams that do that, they may not know the number, but they know what the rule is, and we can find the number. But being able to do those little details, to me, set a great team apart from a good team.
Thanks so much. Fred, I'll ask you the same question.
Well, when I'm evaluating the teams as a whole, and I think most people do that, you look at the three people and you say, okay, that person's an A, that person's a B, that person was a C. And then it's A, B, and C versus a team that's two A's and one D, and that's a problem. What do you do? But what makes an A team where they're generally together, they're stronger? We're doing them individually, but when they add up, we sort of say, okay, this is generally a better team, not three people. And the team is, as I think, as everybody said, is that they're acting assertively, like they own the place. They're acting coordinated. They're all working on the same sheet of paper. They're all going in the same directions. We can see from their directs and their crosses that they are aimed at the same place that we learned about in the opening statement and that we're going to hear about in the closing argument. And somebody said flexibility. Yeah, sometimes a witness will give you a golden nugget that you never expected was coming. Boom, there it is. And you've been able to work it into your closing argument, even though you didn't expect it. That's flexibility. And that's what Steve was talking about. But again, arguing, knowing when to object and when not to object. It's just the whole package. And so we're looking at a team where everybody has the ability to do all those things. And when that's true, we have an exceptional, a really outstanding team that is probably going to win.
Jamie, same question.
Okay, so I'm going to riff off the flexibility point a little bit, and this is pretty specific to cross-examinations, but also applies to closings. And that's, if you're an attorney, listen to the answers that the witness is giving you. If you're a witness, really listen to the questions that you're being asked, because we can see sometimes that what happened, maybe the answer that the witness gives you, you didn't expect. But instead of going with that and seeing what you can make from that, sometimes teams will just go back to their script. And that's a good team. A great team is the one that kind of throws away the script and says, okay, my witness is going on this path instead. I'm going to see how far I can take them here and how I can turn it around to my advantage. So that kind of flexibility is something that I definitely look for when I'm seeing, okay, is this a team that is really great at what they're doing? Being able to roll with those punches, because in almost every trial, something unexpected is going to happen. So one of the things that judges look for is, how do you deal with that?
Thanks so much. And Sanford, last question, or question to you as well. Sorry.
It is hard going last after these folks. I'm going to agree with pretty much everything that was said. I will add to it though, the teams that make sure that this is not personal, right? Whether it's the objection or you're crossing someone or whatever. The point is to remain calm and again, keep your focus and your confidence. But regardless of how they all do it, this is, as you point out, it's not necessarily the end of the world. But just keep focused on where you're going. The one last one I would say is your theme. For those of you that have a theme, the idea of everyone going in the same direction, you're going to want to try and work your theme into every time that one of the attorneys steps forward.
Could I say something
Yes, of
about the
course.
theme? I think that's great because, you know, you got to not only have a theme of what happened, factual theme, and a legal theory, how those facts under the law mean you win, but you have to have an emotional theory. And that is you're grabbing them not only in their head, but you're grabbing them in the heart or the stomach. And so the whole team has to get down and decide it originally, right at the beginning, and say the theme of the emotional theme, and that is the theme that we're going to use that will tell the jury why they want to find for us, why it's right to find for us, why it's justice or it's fairness or whatever, that to find in our direction, and then work that theme out throughout the entire trial. It may be, you know, they broke a promise, it's time now to hold them responsible for breaking a promise, or they acted unfairly, or they committed a crime, or whatever it is. But you got to have that emotional theory and work it out. And so I agree with that very strongly. And when the really good teams are the ones who have figured out an emotional theme to spin out during the trial.
Absolutely. So Sandra, I'm going to come to you first with my next question then. Something I'm sure the students are wondering is when you're picking your best witness and your best advocate, and what factors are you looking at when you make that decision, pick that student?
So first, looking at the best advocate, I'm really focused on the person that is confident, is unflappable, is a term that you often hear about good litigators. We are looking for someone that knows not just their facts, but is able to respond when things change, when they get a odd fly pitch. But in terms of the witness, I think that's kind of the one that's a little more nuanced. Like one of my other judge friends has mentioned here, when you have someone that's completely into the role, that's wonderful, and it's great to see, especially when you see an entire team of them. But you can also see the people that you just are kind of unassuming, and that's what feels really, really real, because you have this advocate that just showed up and they're feeling a little weird about being in a courtroom, but they are still on point about all of the elements of the case.
Jamie, what about you? Kind of what do you look for when you decide who your best witness and best advocate are?
So I definitely agree that confidence plays a big part of this, and the confidence, like I said before, to go off script when necessary. And that's true for advocates and witnesses. For witnesses, I do think that the way that a witness handles questions is something that I very much take into account when I am selecting my best witness. And again, a witness that really listens to the question and answers it and isn't afraid to answer with a yes or no on cross, because the witness isn't concerned with, do I need to win this case in this question? And it's more, let me just answer the questions. And if it's a yes or no question, I can answer with a yes or no, and that's okay. So a witness that's able to make that distinction between, do I need to answer this question to win the case, or do I need to answer this question just to get through the cross and not give them too many points in what they're asking? For advocates, the confidence is really important. Somebody who knows their case backwards and forwards and can deliver an opening or closing that just makes us so that we can't take our eyes off of you because of how confident and how thorough your knowledge is. That's the advocate that I will often give best advocate to.
Thanks so much. And I'll ask one more person this question. Fred, best witness, best advocate, and what factors are you looking for when you make it?
Well, with regards to witnesses, I'll tell you what loses points, and that is one, not knowing the facts. You just are not prepared. You don't have it down. You obviously haven't practiced this extensively with the persons asking the questions. Two, you purposely try to waste the other side's time by refusing to answer the questions and evading them as if you've been instructed. Spin this out as long as you can, waste their time, they'll run out of time. That's in our advantage. When I get to I know you can be somewhat evasive and indirect in some of your answers, but when it becomes pretty clear that this is an intentional effort to waste the other person's time, you lose magnificent amounts of points for me. And in a way, I want to punish not only your team, but probably your coach, if your coach lets you get away with that or even put you up to it, because that is wrong. And now as to counsel, I think everybody said it is the person who we go, wow, that looks like a real lawyer. I mean, they were confident, they took control, they made things happen when things had to happen, like saying, I'm sorry, Mr. Witness, the jury can't hear you. Would you please speak up? Do it. You're in control. You make things happen. You know the rules of evidence. You know the facts cold. You know what you have to prove or what you're trying to disprove. And it just is, we go, wow, that's as good as any new lawyer I've ever seen. And that's the person who will come out as the top advocate.
Thank you so much. With that, Fred actually kind of got me to my next question, which is, what are some pet peeves that you see with attorneys or witnesses? Kind of some things you see that they're not necessarily wrong, but they might bother you a little bit. Fred raised one point that we see sometimes in competition, which is having witnesses who are unreasonably obstructive. And so I'll kind of ask if any of y'all have any of those and any types of pet peeves. So I'll ask you, Catherine, any pet peeves that you've seen in mock trial rounds?
That's one of my pet peeves, is witnesses who will not answer the question, who just spew out the same script every single time, and actually get to the point where it looks like they're intentionally trying to, waste time. That is my main pet peeve. That's it right there. He encapsulated it for me.
Right, Jim, what about you? Any pet peeves you've seen in mock trial rounds that you would advise against?
Well, I think the witnesses stalling on cross-examination is a big one for all of us. Fred has described it very well. I'll add one for lawyers. Students in lawyer roles, they learn their roles initially by a script, and they need to get off of that script and be paying attention to what actually happens during their round so that they can adapt. Too often, the lawyer does not listen to the witness's answer to the question he's just asked because he's thinking about the next question on the script that he needs to ask. The witness will give you an Easter egg and you'll miss it completely because you're locked onto your script. So I want to see the lawyers paying attention to what actually happens in the courtroom and adapting to it.
And Stacey, finally, I'm going to ask you the same question. Any pet peeves you've seen in rounds that kind of just get on your nerves a little bit, or you think affect student advocacy, anything like that?
I think as a presiding judge, when objections come up again and again, or, and they just won't let them go, and it's not helping the trial move forward, and the judge has clearly ruled on it. I think that's something. So I think kind of like back to what we said earlier, look at your judge, listen to your judge, look at them again so that, the judges will telegraph, like they don't want to hear it. And you're going to lose points because advocacy, a big part of advocacy is, knowing the room. That includes the judge.
Absolutely. That's great point. And now I kind of want to break down, I guess some of the questions we've gotten from students have to do with the different components of the trial. And so first I want to talk about, I know openings and closings are different, of course, and have different strategy, but I do want to ask Sanford, when you see an opening or a closing, kind of what do you think makes those effective? I know we've talked about themes already. Anything else that you want to comment on that makes an opening or closing particularly good?
I think being focused, when you're really going to, again, beyond the theme, because I think that's super important, and I'll point out kind of the recency bias. The two most important times are when you first start an opening and closing, and when you just are closing or ending your opening or closing. But They're in the middle. Look, don't belabor the point. Don't try and stall or whatever. If you're not remembering exactly where you wanted to go with this, keep it short, keep it sweet, and focus on what you want to say so that they are more likely to remember all of your words.
Awesome. Thank you so much. And Fred, what about you? Kind of what do you look for in a really effective opening or closing?
Stories. We live in stories. We tell our friends what happened, it's a story. We read books, it's a story. We watch TV, it's a story. We go to the movies, it's a story. Everything is a story. We live and breathe stories. Turn your case into a story. This is the story about a man who, whatever, broke a contract. This is a story about somebody who was killed. And so whatever it is, reduce it to a story. And that will keep the jury's attention rather than just simply saying, so-and-so is charged with this, witness one will testify this, witness one will two will testify, witness three will testify. Boring. And besides, you expect us to remember all that stuff? Come on, put it in the context of a story. You're going to learn from the evidence that this is what happened on a certain day, and that you tell the story, okay? You just, and closing argument is the same. It is the story of what you want the jury to believe happened, which causes you under the law to win. And so tell a story. That's all I can say. Also, the other thing is I just get irritated at the standard operating procedure where everybody seems to have been told that what you do is you start your opening statement, and then you stop your opening statement, and then you introduce everybody who's on your team. Why would you do that? Why would you interrupt the story and do that? Now, I know you're trained to do that by people who think that's the way it ought to be done. As it was suggested by Jamie, it is not necessarily one way to do it. And let me ask you to think about whether that makes sense.
Thanks so much, Fred. And I couldn't agree more. I love to hear a story in openings and closings. I agree, that's how we relate to people. So one thing I want to talk about also is direct examination. What do you look for when you're evaluating what's a really great direct examination? Jim, can I ask you that question?
Sure. I think a direct, if done well, looks like it wasn't hard at all. I think a good direct examination, the witness is the star. The examiner is the guide who guides the witness through the story that the witness needs to tell. The examiner does not distract from the witness or the witness story. The examiner is always there with the next question, the goal being to lead efficiently through the testimony and allow the witness to shine. The very best directs are so smooth and so efficient that you wind up thinking, well, was the lawyer even there, or was it just the witness? That's a good direct when the thing the observers remember is the witness and not the lawyer.
And I want to turn to cross-examination, which is my favorite part of the trial.
Can I add something about direct?
Yes, of course.
Really critical. I agree. Everything Jim said is right. You got it. But I look for who, what, where, when, how, why, or describe. Every question should begin with who, what, where, when, how, why, or describe, because it can't be leading. It's not leading. You won't get bogged down in objections. And every single question has to start with one of those words and contain a question that asks for one single fact. When I get a direct examiner up there who asks all 9 leading questions and has nice, tight little questions that ask for only one fact at a time, baby steps is what we're talking about, baby steps to it. I think that's a really strong direct examination.
Thank you, Fred. And Catherine, I want to ask you about cross-examination. What are you looking for in a good cross?
A short, concise cross that makes your point. Crosses that hit every single fact that might be in somebody's statement and meanders and doesn't make a point they're just a waste of time. They're a waste of your time, they're a waste of our time. You need to know what is your goal in cross. And it's usually to make a specific point that whatever they just said, that's not wrong. Well, how are you going to get there? By going through every potential fact that might exist in the story is not going to get you to your goal. Find the facts that help you. Use them. Short, pointed questions, and not meandering, and we don't need any just diatribes from the witness. Just short, to the point, with relevant information. That's a good cross.
Stacy, I saw you clap during that, so I want to ask you the same question, because I can tell you agree with what Catherine had to say. Do you have anything else to add about what makes for a good cross?
Well, I mean, I 100% am behind what she said. I think if you want advice on cross, like, that is it. The only thing I would add is know when to sit down. You don't have to fill a ton of time. This doesn't have to be 10 hours in the spotlight. If you got your points across, sit down.
And I'll bounce off of that and add my one little nugget is, like you said, know when to sit down, know when to stop, and know when's a question too far. Because sometimes you can ask that question too far. And so it's, if you've got a really good answer and you feel like, okay, well, I've gotten done what I need to get done, like Stacy said, stop. And then sit down, and you will have made a big impact, as opposed to giving the witness the chance to wiggle out of the really great work you've done. So I think those are really great points.
Yeah, Irving Younger always taught that cross-examination is a hit and run invasion, not the invasion of Europe. It's, you get in and out because that witness is not there to help you. Okay. Also, with regards to I'll just jump in here. Again, what I'm listening to is I want a cross-examination where every single question is leading. And that can be answered only with yes or no. And again, it asks for only one fact, because that's the only way you're going to be able to ask nice, tight leading questions is one fact at a time. But it is, you tell the witness a fact and ask them whether to affirm it or deny it. That's a leading question. You tell the witness what you want to get from them. That's it. You were at the party, yes or no? You weren't there before 9, were you? Something like that. Those are tight cross-examination questions, which really nails the witness to answer cleanly and not go on and spend your time. So leading questions as opposed to a direct examination, open-ended questions, all open-ended questions.
Absolutely. And I want to turn next to objection practice. I think, because we've already heard some different opinions on this issue. How much is too much? Are we following a less is more or more is more approach? And so, Jamie, I want to ask you to speak on that topic, since we've heard from a couple of folks on that already.
Yeah, and I am confident that every judge on this panel and every presiding judge that you're going to see has a strong opinion about objections. So what I say might be kind of controversial, and that's okay. It goes back to, there's no one right way to do this. And because you're going to hear from some of us about our thoughts and our preferences about objections, doesn't mean you should change what you're planning to do based on what any one of us says. This is all just food for thought and stuff to take into account while you're preparing. All of that being said, my preferences on objections are very much, I want to know that you understand the basis for your objection, but I also want to see that you are lodging objections because they matter. And so it's not enough for me to see, okay, this person objected to this question and that was a valid objection. I also want to see that this person understands that this objection, if they win it, is actually going to give them an advantage in the trial. And so for me, less is more, because almost every question that is going to be asked could be seen as objectionable for one reason or another. But if you have that kind of restraint that you're not objecting to every single question just to show that you know how to object and you know the rules of evidence backwards and forwards, but you are limiting your objections to the questions that you know if you can get that question thrown out, it's really going to matter for you, to me, that is the sweet spot.
Thanks so much. Now, I just want to get to a couple more topics real quickly before we, I'm sorry, do you have something to say, Fred?
Pet peeve, questioning a witness. There's an objection's overruled, and counsel goes on to their next question and doesn't get the answer to the question that they just won the answer to. Get the answer that you just won from winning the objection. Go on, don't go on to the next question until you get it. I see that all the time, and that's just irritates me.
Thanks so much. One question that we got from a couple of the teams had to do with expert witnesses specifically, and kind of wanting to understand what you expect when you see an expert witness in your trial when you're dealing with them as the presiding judge. Specifically, do you expect that expert witness to have to be formally tendered? And so, Jim, I want to ask you that question. Kind of when you're dealing with an expert witness as a presiding judge, kind of what's your expectation there for teams to really effectively introduce that witness?
I don't think that an expert needs to be tendered formally. I think, though, that counsel would be well advised to pay attention, a lot of attention, to expert foundation right up front, lay the foundation. What I like to see with an expert, and this happens a lot, a lawyer will introduce the expert, will lay some foundation, but then we'll try, in the interest of time, to jump into the substance of the expert's testimony. And a good team on the other side will pop up and object right there to foundation. This person's not an expert. And they'll make the other side go back and lay the other planks of that foundation that they were trying to skip over. Just go on and lay the foundation, assuming that your expert's qualifications are going to be attacked. On the other side, when you see someone obviously tooling up an expert witness, prepare to attack that witness qualifications. Do not let that slide. If there's a means to attack, do so. Do it early. Don't wait for a formal tender. Don't wait for the presiding judge to say or do anything. Do what you need to do to represent your client and let the chips fall.
Couldn't agree more. I think that's a great approach. And then I want to ask one final question to the panel. What is something you've seen mock trial participants do that you wish you saw more actual trial lawyers do? And Sanford, I want to ask you that question first.
It's probably one of the hardest.
I can come back to you.
I'm going to need it, Allison, please.
Anybody got a good answer for that one?
Showing due respect to the court and knowing all of the decorum that is required in a formal proceeding. I think sometimes real trial lawyers get too informal, and maybe the judge invites it. But at least in our situation, where you're literally in front of a new judge you've never been in front of before in a court you've never been in before, you need to make sure you know and you follow all the rules of decorum. I see students all the time when the judge says, do you have any more witnesses? And their answer is no. They're seated when they say no. Wait a minute. You're talking to the judge. You got to be on your feet every time you say anything, even one syllable word to the judge. You got to be on your feet. And I think that lawyers sometimes really get kind of slovenly in terms of showing due respect to the court. And the students do better.
They really do a great job with that. Catherine, I thought I saw you raise your hand, so I'm going to turn to you next for that question. Kind of what is something you see our high school mock trialers do really well that you wish you saw in more professional attorneys?
Remaining polite to the other side, which is part of decorum and professionalism. But real trial lawyers, when they're in the heat of the moment, can, snap out and be snarky. And I have seen the mock trial students be able to maintain their professionalism, their calm, even when speaking, directly, you can't talk to the other side, but they're maintaining politeness, just basic courtesy of the other team. And I wish more trial lawyers in the real world would do that.
You and me both. Jim, what about you? Kind of what are some things you've seen our high school students do really well that you wish you saw in attorneys you face on a daily basis?
Well, now I'm going to go micro on you. This seems like a silly little thing, but I think it matters. Mock trial competitors are new to the field. They're new to evidence, and they therefore are taught to do things in the way of a drill. When you offer a document into evidence, there is a set way you do it. There are 4, 5, or 6 questions that you will ask in the correct sequence about that document in order to lay foundation so that you may then offer it into evidence and hopefully deflect foundational type objections. They do it by the numbers every time. That's what they're taught. I wish all of us would remain that disciplined. Unfortunately, we don't. We slip, we skip, we cut corners, and sometimes it's fine, but sometimes it trips us up. We all would do well to do certain things by the numbers, just the way we learned in the beginning.
Thanks so much. Sanford, what about you?
So I think this is maybe a small one, but I think it is about attitude. I would say that regular attorneys, I guess, at some point we become a little jaded, and which means one, that we don't seem as energetic towards the end. Unlike people in mock trial, I've seen them, smile and be excited to be there from the moment they walk into the room to when they walk out. But also, they understand to some extent that this is not to say it's a game, but the importance here is that we have a fair trial, and that is conveyed. And I think attorneys may lose sight of that once we get a little older. So that's refreshing, and I appreciate it.
That's fair. Jamie, what about you?
The level of preparedness. I am so appreciative when mock trial participants come in and know the facts backwards and forwards. And that is something that I wish lawyers, real life lawyers, did. Because the best way to prevent from being rattled when things go sideways in a trial is to know your facts backwards and forwards, because then you can move on to a new plan if you need to. So just that level of preparedness, especially in the later parts of the season where you've done this a bunch of times and you have every fact statement basically memorized because you've done it so often. I mean, that shows, and I do think that's something that real life lawyers could take a message from, is just be over prepared, and then you can become more confident because of that level of preparedness. And then Allison, you've been such a great moderator, but I want to turn this question on you too. What do you think?
Something that I like to see, and I coach mock trial at the law school level. Obviously, I'm a practicing lawyer as well. I like that. I feel like by and large, our high school students, the attorneys and the witnesses have a good rapport with one another. I don't see a lot of attorneys cutting witnesses off, for example, or being rude with witnesses, which is something you see at the law school level. It's something you see in practice as well. And so I do like that our attorneys generally know when to get that yes or no answer. They know when to do that appropriately, and they generally treat the witness with respect. So that's something I like to see from our students. I also think every year we hear so many times from our presiding judges, our scoring judges, that so many of you are so talented that we think you could be practicing lawyers. You could step in the courtroom today. We'd love to hire you when you get out of law school someday. And so I think that's a testament to all the work that all of our wonderful students do. With that, I think we're going to bring the panel to a close. We are so excited to see all of you in January, February, March in our upcoming state and regional competitions. Thank you so much for watching this presentation today. We hope that it was helpful to you, and we wish you all the best of luck as you prepare for your regional and hopefully state competitions. So thank you all so much. Thank you to our wonderful panel of presiding judges who were here with us today. They had some great insight, and we thank them so much for being here to share it with us.